Hello friends, Namaskaram. Myself is Dr. Soni. In today's class, I will discuss an important case recently decided by Honorable Supreme Court in favor of accused, wherein the accused persons has been discharged from the offences under the PC Act. First of all, we have to note down the title of the case. Title is R. Ashoka versus State of Karnataka. Judgment date is 16th of December 2025. Citation is 2025 INSC, page number 1441. In that case, a complaint was submitted to Lokayukt. The allegation was that the accused petitioner was acting as chairman of a committee. The committee was assigned with the role to allot the land to the poor person and to the person below the poverty line. Ultimately, the land is not allotted and finally it is misappropriated. The matter is submitted, the inquiry was held, but the Lokayukt found the allegations as non-genuine and finally the complaint has been dismissed. Second complaint has been filed before the Lokayukt on the same allegation. It was also dismissed with the same reasoning. And finally, the third complaint is filed before the Anti-Corruption Bureau. But Anti-Corruption Bureau lost the FIR. The accused had submitted the petition for quashing, but it was rejected. And finally, he submitted the petition before Honorable Supreme Court. Various grounds had been submitted. Please be noted, ground number 1, there is a delay in the FIR. As we know that in FIR, we are having column number 8, and usually the column is not considered by the anti-corruption or by CBI or by the vigilance. But the column is quite important. If there is a delay in lodging of the FIR or report and the delay is not explained by the prosecution, it is fatal. So the said point has been submitted by the concerned accused. So whenever you are having the same consent and the FIR is delayed, in that scenario, you may challenge the proceeding on that count as well. But the specific formula is that the delay is required to be explained. If delay is not explained, in that scenario, it is fatal for the prosecution. In addition to this, the case of the defense is that basically he is acting as chairperson of a committee, but basically the committee is recommending body. The land is not allotted to any person. So when the work is not pending, in that scenario, there is no question to discharge the official function in the illegal way. So on that count, the proceedings had been challenged. As we know that if the accused has been booked as per section 13 subclause 1 subclause D of PC Act, the prosecution has to show that the criminal misconduct has been committed by the accused. To do this, they have to show that he is assigned with a duty and he had discharged the duty in the illegal way. If duty is not allotted and apart from that he is not competent for the work assigned as per the FIR, in that scenario, the accused is having a very good case to ask for the discharge from the alleged offense of criminal misconduct. In addition to this, sanction is imperative. If sanction is not taken, basically sometime prosecution says the work is illegal, that's why sanction is not required. I want to clarify that if the concerned accused is booked as per section 7, 11, 13, 15 of PC Act, sanction is imperative. If sanction is not taken, apart from that, it is accorded by the authority who is not competent. In that scenario, the proceeding could be challenged. In addition to this, it is submitted that the allotment is not illegal because no one has come forward to challenge the allotment. So basically, if the allotment is as per the norms, the consent petitioner is not competent to allot the land. In addition to this, the sanction is not available. The report is lodged with a great delay and no explanation has been accorded regarding the delay. In that scenario, it is a fit case to discharge the concerned accused. Honorable Supreme Court has observed the entire case and it is submitted that in the present case at hand, the concerned complainant has submitted the multiple complaint on same set of facts. Two of them has been disposed of at the stage of inquiry by the Lokayukt, but third of them has been converted into the FIR by the SCB without any basis, because during the course of inquiry, it is submitted to the concerned Anti-Corruption Bureau by the accused person that the matter has been closed by the concerned Lokayukt, and on same set of allegations, multiple complaint has been filed. So, on same set of allegations, if certain complaint had been disposed of with a specific reason, in that scenario, the other agency could not lodge the report on same set of fact, but the concerned SCB has failed to consider the said scenario, and that's why Honorable Supreme Court observed that it is a fit case for intervention. And apart from that, sanction is imperative if the concerned accused is going to be booked as per section 7, 11, 13 and 15 of PC Act. Sanction is imperative. If sanction is not taken on the ground that the act is illegal, in that scenario, the proceeding will be vitiated. Sanction is imperative. No sanction, no case. Please be remember and mark my words. And apart from that, the co-agent specifications must be on record. On mere surmises and conjecture, the proceedings cannot be allowed to continue. So, entire things were in favor of accused, and finally the proceeding had been quashed. So if you are having the same trouble, means there's a case against you, and inter alia you are going to be harassed by vigilance or by CBI. First of all, you have to ascertain the nature and quality of allegation. For example, it is concerned with your official duty. You have to specify whether these duties are pending with you or not. If the duties are not pending, you have not abused the official function in the illegal way, you may take the benefit. And apart from that, just see or observe whether sanction is accorded or not. If accorded, whether it is by authority competent or not. If it is not, and apart from that sanction order is mechanical or cyclostyle or indicating the non-application of mind, we could be succeeded in our case. So basically we have to keep in our mind all this point while moving for the questioning before High Court or before Honorable Supreme Court. And in addition to this, you may submit a gyapan or memorandum or representation to the concerned authority with a request to investigate the same if during the course of investigation or inquiry the concerned authority failed to investigate on the point submitted by you. In that scenario, you could chalk out the case for unfair investigation and could be succeeded in your plea. See you in the next video. Till then, Jai Hind, Jai Bharat.